Good evening. Happy Wednesday. We're going to start off with Earl. It appears that his trial is moving forward. They were voir direing jurors, potential jurors today. Voir dire just means they get to ask questions to try to figure out which jurors they want to excuse and which jurors they're okay keeping. There was apparently an issue with a overzealous idiot who wanted to talk to jurors during one of the breaks. That would be Dougie Fresh, the crayon eater. Also goes by I'm A. You'll see him sometimes down in my comment section calling me an idiot. But he's the kind of guy who thinks that justice needs him to be accomplished. He likes to insert himself into trials and things like that. Real retard. Anyway, despite him, it looks like they're coming back tomorrow to continue voir direing potential jurors. It appears that the actual trial is set for February 23rd, 2023. Now, for those of you who... clicked on the wrong thing. For those of you who were curious about the demand for speedy trial, that was, it wasn't a demand, it was a motion for speedy trial, motion to dismiss for lack of a speedy trial. And it was denied. Now, if only somebody could have predicted that it would have been denied. If only someone could have predicted it would have been denied. That would have been crazy. So it does appear that the trial is set to start on the 23rd of February, and they're just voir direing jurors. I don't know why you would voir dire jurors for something that's going to happen in a little over 2 months, but it's Texas and they do things different down there. Now on to Chili's case. This is Decastro versus Abrams et al. There was some shenanigans today. Chili filed a motion basically asking for permission to appeal. The judge denied it. Yes, I realize I'm not bearing the lead, but we're going to go through it. And then the court staff made a correction where they split 82 into 82 and 83, which bumped the order to 85. We'll get through it. We'll make sense of it. So first off, the Federal Rules of Appellate Procedure, FRAP, as opposed to the FRCP, tells you how you have to go about getting permission to file an appeal by permission. See, there's appeals by right. Anything that ends your case, you can appeal. Well, not anything. I mean, you have to actually have grounds for the appeal, but you can appeal something that ends your case. So if opposing party files a motion to dismiss and it's granted, your case is done, right? You can appeal that. If the opposing party files a motion for summary judgment and it's granted, then you can appeal that. If you go to trial and there's some error at the trial that you don't like, you could probably appeal that because the case is done, right? Those are appeals by right. Now, appeals by permission are different. Appeals by permission are things that don't end the case. They're appeals by permission. You have to ask the trial court. It says to request for permission, you have to do this, this, and this. If a party cannot petition for appeal unless a district court first enters an order granting permission to do so. There are some things that you have to ask the district court for permission to do. or some appeals you have to ask the district court for permission to do. And one of those things is an interlocutory appeal. An interlocutory appeal is an appeal that is to challenge an order of the court that does not end the case. For example, if you disagree with the judge's order on a discovery motion, you might want to appeal it, but you don't have a right to appeal it. So you'd have to ask the district court for permission to appeal it. Otherwise, you have to preserve your objection and wait all the way till the end, all the way till you lose the case to appeal it. Obviously, if you win the case, you're probably not going to appeal. So you have to wait till you lose the case to appeal these things. And some people don't like to do that. So they want an interlocutory appeal. An appeal while the underlying case is still pending. So this is what Chile originally filed. It is a 6-page document that starts off with the motion and then the memorandum of points and authorities. So what the court did is what the clerks did is they split it into the motion and then a memorandum of points and authority. So it's still 6 pages. It's just 1 page and 5 page. So that's the shenanigans that happened today. So what did Chile file? This is his motion. Plaintiff's motion for a certificate of appealability. So Chile hereby respectfully, remember that word, respectfully, moves this honorable court to issue a certificate of appealability under 28 U.S.C. 1292b as to 5 particularly vexing questions on which the outcome of the court's orders depend. In support of this motion, plaintiff submits a memorandum of law which is fully incorporated herein. All right. So we have 5 particularly vexing questions, and we have 28 U.S.C. 1292. Let's go to 28 U.S.C. 1292b. When a district judge, in making in a civil action an order not otherwise appealable under this section, shall be of the opinion that such order involves a controlling question of law, as to which there is substantial ground for difference of opinion, and that an immediate appeal from the order may materially advance the ultimate termination of the litigation, he, very sexist, he or she, shall so state in writing in such order. The Court of Appeals, which would have jurisdiction of an appeal of such action, may, thereupon, in its discretion, permit an appeal to be taken from such order if application is made to it within 10 days of the entry of the order, provided, however, that application for an appeal hereunder shall not stay proceedings in the district court unless the district court judge or the Court of Appeals or a judge thereof shall so order. What is this saying? This is saying that if the district court judge gets this request for appeal from one of the litigants, and the judge thinks that, number one, this is a controlling question of law. We need to know what this particular law means in order to be able to go to trial and get resolution of this issue. That's number one. And there has to be substantial ground for difference of opinion. What does that mean? That means that nobody knows which way it's supposed to go, and different courts have figured it out differently. And so there's no real clear authority. There's no real clear way to interpret this particular law. It's not that the moving party thinks there's substantial ground for difference. It's that there's actually different legal opinions, different maybe district court opinions, but probably circuit court opinions that that resolve the legal issue in different ways. And then the Court of Appeals gets to figure out whether it wants to take the appeal. It might not. It might just be, you know what, district court, you figure it out. We don't really care. That's what this says. So we're going to have to figure out if what Chile says involves a controlling question of law that has a substantial ground for difference of opinion. That's what we have to figure out. So this is his memorandum. Plaintiff asks the court to issue a certificate of appealability for an interlocutory appeal pursuant to 28 U.S.C. 1292b. By certifying this appeal under 28 U.S.C. 1292b, this court will provide the First Circuit with occasion to pronounce more broadly on these unresolved, but important questions. A. Nunc pro tunc filings take effect retroactively. That's literally in the name. Now for then. That's literally what they do. The court's orders have construed intergen NV with Grena to mean that all motions filed prior to an amended complaint are rendered moot by the amendment, including nunc pro tunc motions to correct the record, nunc pro tunc notices for voluntary dismissal, and motions to nunc pro tunc correct the record of a voluntary dismissal. Now, if, in fact, the court does construe intergen NV versus Grena to mean that, then by definition, the district court does not think that there is a substantial ground for difference of opinion. Now, I've read intergen versus Grena, and it dealt with a mandatory arbitration action. And the plaintiff, so the defendant removed it from state court based on mandatory arbitration. Federal mandatory arbitration. And then the plaintiff amended its complaint to remove any of the signatories to the arbitration agreements, and then moved to remand it back to state court. And the defendants moved to force arbitration. And the court said they've amended their complaint. There's literally nobody who's a party to that arbitration anymore. And because they did that, we have to kick it back down to state court. Because there's no longer any parties involved that deal with that. And yeah, we understand so the defendants were like, well, judicial estoppel applies, equitable estoppel applies, because they pled these parties initially, right? And so they're bound by that initial pleading. And the court's like, no, they're not. They're not bound by that initial pleading. Sorry. It's gone. It's gone. So it doesn't stand for what he thinks it stands for. The problem is that the court was using it for a very limited purpose. I think it's in here somewhere. Maybe it's up in here. Here we go. The court was using it for this particular sentence. An amended complaint supersedes the original complaint, and the facts that are neither repeated nor otherwise incorporated into the amended complaint no longer bind the pleader. So he filed a new complaint. That's all the court's saying. You filed a new complaint. In other words, by filing the amended complaint, you replaced the original complaint and mooted any motions related to it, including your motion to retroactively change the filing date of your notice of appeal. You essentially filed a new complaint. You're thinking that that by amending the complaint that somehow any action that would have eliminated the old complaint would have eliminated the new complaint. But it doesn't work that way. Say for example, someone filed a motion to dismiss on your first amended complaint. And let's say they filed a nunc-pro-tunc motion to have their motion to dismiss heard before your second amended complaint was filed and ruled upon before your second amended complaint was filed. Think about that. What about in that case, where it's somebody doing something you don't want them to do, i.e. file a motion to dismiss to get rid of your complaint? And the court says you can file a second amended complaint. Oh wait, but they want to do a nunc-pro-tunc to have their motion ruled on before you file your second amended complaint to get rid of the first amended complaint. And if the first amended complaint's gone, then the second amended complaint doesn't take effect. But that's not what happens. That's not what happens. Because if, let's say that Kate Peter filed a motion to dismiss based on a failure state of claim upon which relief can be granted on your second amended complaint. Let's say that happens, right? If you amend your complaint, the court moots that motion. Kate can't then file a nunc-pro-tunc to have the court rule on that motion before you file the second or the third amended complaint and get the case dismissed. The new complaint supersedes the new complaint. You're filing a new complaint. You're once again availing yourself of that court. You're giving that court jurisdiction over you and over your issues, over your allegations, over your complaint. I don't know how to explain it any more clearly. It's so obvious that the court really doesn't need to cite anything. It's just a thing. This is just, what you're doing is so stupid that a court of appeals is never going to make a ruling on it. You're not going to find something directly on point because what you're doing is just so stupid that a court of appeals is going to be like, no, the district court was absolutely right. We're not even going to deal with this. We're not going to waste time on this. We're just going to deny your appeal without opinion because it's obvious. Because it's obvious. You had this pending nunc-pro-tunc motion and then you filed your second amended complaint? Of course. Or first amended complaint. Maybe it was your first amended complaint that you filed. But of course, as soon as you filed that first amended complaint, of course, your nunc-pro-tunc motion to dismiss is gone. Of course it is. It's just obvious. And I don't know, I can't explain to you the color orange. You know what I mean? It's a thing that everybody knows. But if you don't know it, then I can't explain it to you because it's just obvious. The color orange is orange. You know what I mean? Once you file an amended complaint, any pending motion to dismiss is mooted. Any pending motion to dismiss, including a nunc-pro-tunc motion to enter a voluntary dismissal. Any motion to dismiss is mooted. The legal description of nunc-pro-tunc motions can reasonably be read that notices of dismissal entered nunc-pro-tunc to be effective at a date prior to the amended complaint should instead make the amended complaint moot and not the other way around. And the case cited by the court doesn't say otherwise. That'd be like saying the legal description of a nunc-pro-tunc motion to dismiss, or the legal description of, let's just say, not just a regular motion to dismiss, the legal description of a motion to dismiss can reasonably be read that as soon as the court grants the motion to dismiss, the court can no longer also grant the plaintiff a opportunity to amend. But that happens all the time. It's just stupid. Local ECF rules, this is B, local ECF rules, sorry if you're having trouble reading this, local ECF rules don't define when a document is filed. The court's orders have construed its local rules regarding ECF filing as superseding the First Circuit's definition of filing, as well as Federal Rule of Civil Procedure 41A, which says the plaintiff may dismiss an action without a court order by filing a notice of dismissal before the opposing party serves either an answer, ... Let's look up FRCP 41. Shoot. FRCP 41. By filing a notice before the opposing party serves. So you didn't file it, and you were served. I don't understand the point. Okay, so what is the First Circuit's definition of filing? That's First Circuit Court of Appeals. FRAP, that's Court of Appeals. Here's filing, Rule 5. Filing requirements, a certificate of service. Any paper after the complaint that is required to be served must be filed no later. Okay. Disclosures, filed, certificate of service. If the paper is filed, a certificate of service must be filed with it. Non-electronic. Paper is not filed electronically if it is filed by delivering it, ... Electronic filing and signing by the represented person, by an unrepresented person. When allowed or required, a person not represented by an attorney may file electronically only if allowed by court order or under local rule, and may file or may be required to file electronically only by court order. Okay. I don't understand. A filing made through a person's electronic filing account and authorized by that person together with the person's name on the signature block constitutes the signature. A paper filed electronically is a written paper for purposes of these rules. The clerk must not refuse to file a paper solely because it's not the form prescribed by these rules, and the clerk didn't. So I don't understand what he's talking about. He's just making stuff up, I guess. What is the First Circuit's definition of filing? The First Circuit Court of Appeals? An appellate filing? Is that what he's talking about? Well, this would be a filing in a district court, not a court of appeals. So I don't understand what he's going for. And the plaintiff may dismiss an action without a court order by filing a notice of dismissal before the opposing party serves either an answer which does not specify where the filing must be made or the manner in which it is to be filed. Well, you can either do it by a paper filing. Oops. or by an electronic filing. And paper filing a paper not filed electronically is filed by delivering it to the clerk or to a judge who agrees to accept it for filing. Did you do that? No. So then we have to go to electronic filing and signing, and it has to be filed. You have to file electronically. Did you file electronically? No. So I don't understand where we're going. I'm sorry that I keep saying I don't understand. I really don't understand. The Second Circuit Appellate Court has held that the ECF is not, strictly speaking, a local rule which has the force of law. But the FRCP has the force of law. The courts have to abide by this. They don't have a choice. The courts have to abide by the Federal Rules of Civil Procedure. And this is Phoenix Globe Adventures. This is, I don't remember this one. This was the one where they immediately found the issue and sought to correct it. So his first two attempts to file the remand were within the deadline, but his third was not. On his first attempt, the electronic filing system rejected his filing because his exhibits were too large. Your exhibits were too large. He actually attempted to file it, but it was rejected. He then corrected the error and made a second attempt, which he, in quotes, was assured that the filing was successful. The next day, he learned the ECF had filed the system due to an invalid hearing date. He made a third attempt to file, which was successful. Did you make 3 attempts to file? Was your first filing rejected because your exhibits were too large? See, the point of this case was that because the ECF rejected it because his exhibits were too large, well, that's some weird rule imposed by the ECF system. The courts don't have a rule saying that your exhibits can only be a certain number of megabytes or whatever. That's the difference. That's what you're not picking up. You're not understanding what you're reading. Why can I read it and 10 seconds into it, I figured it out, and you can't? Why is that, Mr. 20-year constitutional law scholar? In a very similar case where a motion would have been timely, but for problems with the district court's ECF system, problems that you can actually verify. It went in and it got kicked out. Again, it went in for the second time, and then it got kicked back due to an invalid filing date. So we have verification, independent verification these things happened. Yours doesn't. You don't even know that you hit the button. These statutes? I don't know. What statute did he cite? He hasn't cited a statute. So which statute? If it's not a statute with a T, maybe it's a statue? Okay. Case law and relevant definitions of the ECF system. Where did he define what the ECF system is? I have no idea what he's talking about. Could reasonably be read that when a party declares under penalty of perjury that it has timely filed a document in the ECF system and provides further evidence of what? That you went to the website? And the court has the best evidence in its possession that this occurred. And the court has the best evidence in its possession that this occurred. Again, dude, you're not going to get what you want. You're not going to get some tech nerd on the stand. You wouldn't even know what to ask him. Like, this isn't happening. You don't get to put the court on the witness stand. The court can't, in the interest of justice, rely on its own requirements of the electronic filing system, move that file to the electronic document, and refused to look at the evidence provided, what evidence did you provide? And the court looked at your evidence. The court looked at your evidence and found it wanting. Or the evidence in its possession. The court doesn't have evidence in its possession. You're assuming the court does. You're assuming that the court has something in its possession, which wouldn't be in its possession, but it would be in the possession of the tech nerds who run the ECF system. But again, it doesn't matter. It doesn't matter because this doesn't end. The court refusing to allow your voluntary dismissal, it doesn't end the litigation. We're gonna get to that in a minute. The party has requested to be discoverable and available at an evidentiary hearing that the document was filed except for an error with the ECF. But if you didn't hit the button, then there's not going to be anything showing on the ECF. C. Trials of fact. The court's orders have construed that it can dismiss evidence presented. It can judge. It can weigh and judge the evidence presented. That's kind of implicit in the name of the person who is running the court, the judge. The judge can judge evidence, and it can determine if evidence is relevant or not relevant. It can determine if evidence is credible or not credible, and it can weigh the value of any particular piece of evidence. And it can, in fact, ignore evidence if it wants to. If it just determines that a particular piece of evidence is irrelevant, it can ignore it. If it determines it's not credible, the court can ignore it. If the court weighs it and finds it to be less weighty than other evidence that is in opposite to it, that contradicts it, then the court can ignore it. Including declarations under penalty of perjury. Declarations under penalty of perjury are not very useful if the court doesn't believe you, as not having any weight, absent contrary evidence. The court's orders have construed that it can dismiss evidence presented, including declarations under penalty of perjury, as not having any weight, absent contrary evidence, and can assume that the best evidence in the court's possession is irrelevant or prejudicial against the party without reviewing the evidence, denying requests for the evidence in the possession of the court to be made discoverable, and denying requests for evidentiary hearings. That is a hell of a sentence. Here's the way it works. When you present your motion, you don't get to say, I think there's more evidence out there. You have to present all of the evidence. And the court looks at the evidence that you have presented and determines from that whether or not it's going to grant what you're asking. And you're saying, well, what if I'm asking for an evidentiary hearing? The court's going to look at the evidence that you've presented. They're going to look at your declaration. They're going to look at your exhibits. And the court's going to determine, looking at those, whether or not it can make a decision right now based on the evidence you've presented, or if it feels that there's going to be some benefit in an evidentiary hearing. So if you don't present sufficient evidence to make the judge think that having an evidentiary hearing would be beneficial, then that's your failure to plead correctly, your failure to present sufficient facts in the form of your declaration and your exhibits, or credible facts, in order to pique the court's curiosity. In Board of Treasurers of the Pipefitters Retirement Fund, Local 597, and Commercial Cooling and Heating Incorporated, the 7th Circuit, which is again the wrong circuit. We've had the 2nd and now the 7th. And this is an unpublished, so this is a district court opinion, which is kind of suspect, just period, in the wrong circuit, which is like a double whammy, and it's not even published. i.e., that judge thought that there wasn't anything of value in it that other people would need to extrapolate from. 3 whammies against it, and this idiot is hanging his hat on this case. Every motion that he's had on this, he cited this Board of Treasurers of the Pipe Fitters Retirement Fund Local 597 versus Commercial Cooling and Heating. Every single one. And it's a shit case to hang your hat on. The 7th Circuit, it wasn't the 7th Circuit, it was a district court. It was not the circuit. It was a district court in the 7th Circuit that held an evidentiary hearing to find evidence providing whether a filing had been attempted. I don't believe I've read this. Someone sent me one of these LexisNexis ones. I don't think I've read it. Someone sent me one that I read, but I don't remember it well enough to actually opine on it. And I'm not going to go through my Discord to go to the link because my DMs I don't divulge. The judge is not expected to be, and this party believes that the judge is not, an expert that can make determinations of problems with the ECF system. But the court likely does have those experts available on staff or a phone call away, and should make those experts available when a party requests them and hold a proper evidentiary hearing. So, if Chili wasn't a dumbass, Chili would have gotten some sort of a forensic computer guy who could go in to Chili's computer and determine everything that Chili did. And then that forensic computer guy would write a statement, or Chili would draft a statement for that forensic computer guy to sign that states exactly what the forensic computer guy found on Chili's computer. That would then lead a expert, Daubert. I think that's what the federal courts use. There's also, what is it, Fry? Anyway, I forget the various expert cases. Anyway, so the expert would then be able to educate the court on what evidence was on Chili's computer that led him to believe that Chili did or did not submit the notice or the motion to dismiss or the notice of voluntary dismissal. But again, Intergen NV versus Greena says that as soon as Chili filed his amended complaint, the voluntary dismissal was done. So this is kind of moot. Anyway, when the court assumed that evidence didn't exist, oh Jesus Christ. So Chili should have provided an expert or something that would lead the court to believe that there was something that the court should look for. So the court is not holding itself out to be an expert. And the court is not making determinations of whether there are problems with the ECF system. The court is looking at the evidence that Chili presented, i.e. the documents, the communications with the clerk, where Chili basically admitted that he didn't hit the button, that he didn't file it. And the court is coming to a reasonable conclusion based on the facts that Chili presented. Chili seems to think that if he doesn't present facts, he can get an evidentiary hearing and he could just basically depose the court's tech guy. And it doesn't work that way. It just doesn't work that way. When the court assumed that evidence didn't exist in declaring it would take no action sua sponte, and the evidence was later provided in a motion, the court decided to look past the evidence and declare it didn't exist, Instead, looked at the metadata of that evidence to find reasons to prove its own preconceived and prejudicial ideas. These sentences are just torture. This is a sentence. For fuck's sake. For fuck's sake. What? Who? Oh, Jesus. This is a long recording, and I'm sorry. So he's assuming that the court assumed evidence didn't exist. The court discounted his evidence. The court didn't have to take action sua sponte because Chile was asking for the action. Sua sponte means like spontaneously, of its own volition. And it didn't do that because it didn't have to do that. Chile said, hey, please do this. Why would the court have to do something sua sponte? And the evidence was later provided in motion. No, the evidence that you provided in the motion wasn't what the court based it on. It was the original evidence with your interactions with the court clerk. That's what the court was basing its motion on, or its decision on. It was evidence that you provided. The evidence that you provided, you thought helped you, and it didn't. Because you're dumb, and you don't understand what helps you and what hurts you. You didn't provide metadata. You provided a history from your browser, a browser history, and you called it metadata because you're dumb. And found other reasons not to take actions in the interest of justice. No, it found that it would not be in the interest of justice to do what you asked it to do. Interpreting typed language severely beyond its literal meaning. You're so stupid. And accepted anonymous hearsay evidence, the anonymous hearsay evidence that you provided. It's literally the evidence that you provided that the court used against you. You dumb shit. In higher regard than a declaration signed under penalty of perjury and evidence admitted by the moving party. It was evidence that you gave the court, you idiot. The court can always construe the evidence you provide to it against you. You dummy. You said this is true. Here's my declaration. And the opposing side isn't going to be like, oh yeah, we don't want that to come in. You dummy, you dunce cap. The common law. Oh, now we're talking common law. What case are we going to cite for common law there, Chili? What case we're going to cite for common law and more statues? More statues. Common law and statutes. Common law you didn't cite, statues you didn't cite. But now we're on to case law, and your sole bit of case law is an unpublished district court case from the wrong circuit. You dunce cap. But that one case, so the common law doesn't exist, statutes don't exist, so we just have one district court case from the wrong circuit that was not published, that could reasonably be read according to you, that the court should accept your declaration under penalty of perjury as true. Should accept your declaration under penalty of perjury as true. Yeah. The court should not make any decisions about the credibility of the evidence. Yeah, just judges shouldn't judge. They should just accept. They should evaluate your evidence. They should evaluate defendant's evidence, determine if it defeated plaintiff's evidence. But see, if plaintiff fails to carry its burden, then the court doesn't have to look at the defendant's evidence. If the moving party bears the burden, if the moving party can't get past the goalpost, then there's no point in looking at the defendant's stuff or the non-moving party stuff, because you've lost already. It's just a waste of time to look at the non-moving party stuff at that point. Especially given the additional evidence provided by plaintiff. You mean after your motion was denied for the 6th time? In stating that the evidence does not exist to make the correction to the record, if there was evidence, the court is saying that its discretionary decision would be to allow the correction with any evidence. No, it's not saying that. It's saying that you failed to meet your burden of proof. That's what it's saying. If you had met your burden of proof, it would have, but you didn't. And an appeal is not where you provide further proof. So what happens at appeal is the court looks at the record that's provided, and the court assumes that any decisions, any findings of fact that the court below it made, so this Court of Appeals would assume that any findings of fact that the district court made are correct. And then based on those findings of fact and the relevant law, the court is going to use a abuse of discretion standard, i.e., is this just blatantly wrong? Is the law that the court applied to the facts blatantly wrong? If it's not just in your face wrong, then appeal denied. But he's appealing findings of fact, apparently, by the court. It's just so stupid. The court has a duty to disclose its ECF evidence, and the ECF isn't perfect. I haven't read this. I'm gonna just wait to see what he cites to stand for the proposition that the court has a duty to disclose its ECF evidence. I'm going to bet you he's not going to be able to cite a case that says anything even remotely similar to the court has a duty to disclose its ECF evidence. The court's orders have construed that when it has the best evidence to determine whether a party filed or would have filed except for the error, that ECF is perfect, that evidence in the ECF system against the perfect state of the ECF is not discoverable, and that the judge presiding over a case is an expert, and requests for evidentiary hearings with experts should be denied. What is with these sentences? I don't think Dr. Law is writing this. I think Mark is not writing this. That's a chilly sentence right there. That's a straight up chilly sentence. Because the court did not construe any of that. That is just all chilly right there. In Phoenix, errors occurred. Phoenix Globe Adventures, a Second Circuit decision. Okay. In Phoenix, errors occurred. Great. But did it say that the court has a duty to disclose its ECF evidence? And in pipe fitters, see, these are not citations. I have no idea why he's doing this. This is not how you cite to a case. In if he had done a in this one right here, if you did a little thing at the end saying pipe fitters, so that he could refer to it later, another thing in here, comma, and then in quotation marks, pipe fitters. Then down here he could say in pipe fitters, comma, Supra, comma, and then a shortened version. I like to see where what page he's citing to. He's just citing to the entire case, though, because he has no idea what he's doing. Just for example, see here where you have the name of the case, the page number the citation is found on, First Circuit, citing this case, and again, having the case number it's found, or the page number it's found on. That's what Chili's missing. He's not actually citing to any particular page, so it's really hard. You have to read the entire case to try to figure out what the fuck he's trying to say. And in pipe fitters, the court accepted ECF wasn't perfect and held an evidentiary hearing with the experts. In pipe fitters, that was the one where it was rejected the first time because the file was too large. It was rejected the second time because an invalid hearing date. It was accepted the third time, but too late. But she had those prior two acceptances, or the prior two attempts at filing, that they had a record of. You see how it's different than what Chile did? The standard rules for review of trials of fact and evidence case law. The standard rules for review of trials of fact and evidence case law could be reasonably read to show that the ECF system is not perfect and that an evidentiary hearing must be held when necessary to find affairs have occurred. He has provided nothing to support anything that he just said. That's garbage. That is just garbage. E. Pro se documents should be read liberally in favor of the pro se party, not liberally against. I believe that is the way it is done. Court's orders have construed the United States Supreme Court rulings that pro se motion pleas should be liberally construed in the most liberally prejudicial way to no, they should be liberally construed. The court has basically a duty on it to read these pro se filings to try to figure out what the pro se party is trying to say. They'll hunt for the meaning. The court will hunt for the meaning. So when Chile filed his letter, this one right here, when Chile filed this, the court had a duty, even though Chile was stupid, the court had a duty to read that letter and try to figure out what Chile was asking for. And the court determined that Chile was asking the court to nunc pro tunc the notice of voluntary dismissal. That's what the court read and understood that letter to request. And that's what Chile wanted. So the court's doing what it's supposed to be doing. Now, it doesn't mean that it has to be construed in the most liberally prejudicial way to the pro se party. It means the court has to figure out exactly what Chile's asking for. The court has to do its best to figure out what Chile is asking for. That's all. They have to, in the interest of justice, understanding that Chile's not an attorney, the court has to try to figure out what Chile's actually asking for. But Chile's still supposed to abide by the federal rules of civil procedure. He's not excused from that. The rulings could reasonably be read. Where did he get this could reasonably be read crap from? That has nothing to do with it. That the pro se documents should be construed in the way most reasonably intended by the pro se party, I think they were, which would typically be in the pro se party's interests, or minimally in a literal way. Yeah, I think the court was doing that. I don't think that the court was not doing any of this. Conclusion. For the aforementioned arguments which clarify the controlling questions of law. Now, so the controlling questions of law in what are we at now? Currently we're in a DMCA. We're in a copyright case. Controlling questions of law would have to do with interpreting copyright law. That would be the controlling question of law. None of these are controlling questions of law. Where substantial difference of opinion exists, there is no substantial difference of opinion on anything that you've put out there. And since this order will materially advance the ultimate termination of the litigation, so the goal is for the ultimate termination of the litigation on the merits. There could be no better example than a question on a voluntary dismissal. Ooh. All prongs of the interlocutory appeal test are met, and plaintiff prays this honorable court certifies these issues for interlocutory appeal, citing some case. Ooh, we actually got a page number. Since these are pure questions of law, they're not. You've literally talked about facts in here. You've talked about the court being an expert witness. See the judge presiding over the case. You're literally bringing up requests for evidentiary hearings. You're talking about facts. The Court of Appeals can decide quickly and cleanly without having to study the record. Even if the district court certified this, the Court of Appeals would instantly kick it back. There's a request for hearing. Request oral argument on the issues presented in this motion. The court has a habit of filling in gaps to evidence and argument not presented in a way most negative to the party. So I don't. So it is the duty of the moving party to present all of the facts and all of the argument necessary to get past that goal, in order to meet its burden of proof. If the moving party does not present sufficient evidence, then the lack of evidence, yes, that means you don't get to the meet your burden of proof part. If you don't effectively argue something that's going to get you to your burden of proof, if your argument doesn't carry you to the burden of proof, then yeah, you don't get there. Like the moving party bears the burden, and any lack in argument or lack in evidence is going to prevent the moving party from meeting their burden. And so it's not prejudicial. The court isn't saying, oh, well, you know, I'm being prejudicial to you. The court's saying you didn't make an argument that actually supported your position, and you didn't provide evidence that supported your position. Because you didn't do that, you lose, because you're the moving party. If Kate had filed a motion and didn't provide the argument or the evidence to support the motion, the court's going to deny it. The court's going to infer that any gaps in evidence are based on a lack of evidence. The court's going to infer any lack of argument is going to be based on a lack of supporting argument. Please allow me to fill in these gaps with a hearing or offer me time to amend this motion before ruling. What? No. So you take the time you need to do the research and gather the evidence before you file the motion. You don't just amend it over and over again, dude. That's not how this works. That's not how any of this works. So the court denied it again today. I mean, it's just obvious it would. The court denied it. The court is not of the opinion that any order entered in this case involves a controlling question of law as to which there is a substantial ground for difference of opinion, and that an immediate appeal from the order may materially advance the ultimate termination of the litigation, and therefore declines to issue a certificate of appealability. Now, I've pulled up a case. This is Carballo Seda versus Municipality of Hormigueros. This is a First Circuit Court of Appeals case. And we've repeatedly emphasized that interlocutory certification under 28 U.S.C. 1292b should be used sparingly and only in exceptional circumstance where the proposed intermediate appeal, interlocutory intermediate appeal, presents one of the more difficult and pivotal questions of law not settled by a controlling authority. As a general rule, we do not grant interlocutory appeals from a denial of a motion to dismiss. That's a general rule. So you're going to say, well, it's not a denial of a motion to dismiss, it's a denial of a motion to nunc pro tunc enter a voluntary dismissal, which is basically the same thing as a motion to dismiss. It's basically the same thing. And as a general rule, they don't grant interlocutory appeals to them. We normally would not allow an appeal from a denial of a motion to dismiss, and with the benefit of hindsight, we admit our error in doing so in this case. This reflects our policy preference against piecemeal litigation, What is Chile trying to do? Chile's trying to do piecemeal litigation, as well as prudential concerns about mootness, ripeness, and lengthy appellate proceedings. Thus, the fact that appreciable trial time may be saved is not determinative, and neither is the fact that the case has tremendous implications or might materially advance the ultimate termination of the litigation. Well, there goes your ultimate termination of the litigation argument. So anyway, I'm sorry for making this so long. It was a horrible motion. I can't believe he had the balls. I can't believe he had the unmitigated balls to file it. Like, I don't know what he's doing. I don't know what he's doing. Anyway, thanks for watching. Have a great day.